Professor Mariann from our hen house, her knowledge overflows. Legislation from cat to pig to mouse, she knows all of those. Critter defenders from across the globe share their stories first to last. So welcome to what we now know as the Animal Law Podcast. It's the Animal Law Podcast.
Welcome to the Animal Law Podcast. We have a great show. It's a really fascinating topic that we have lined up for today. And some of you may have heard, probably a lot of you have heard of Kapporot or Kapporot. It's a religious ritual using live chickens, and it takes place every year in New York City, so it's a bigger deal here than it is in a lot of places. But I was totally unaware of this, but it also takes place in Los Angeles, and it's a big deal within the animal community there as well. And this year there was actually a lawsuit filed in California, and we have the attorney who brought that suit, Bryan Pease, here to talk about it. And it's pretty obvious that this case, which is actually still ongoing, brings up some really fascinating and important First Amendment issues. And we'll be talking about them and some of the other important issues in the case in a lot of detail today. Before we get to that, please consider supporting us in our matching fundraising drive. Please, please, please. As you know, not-for-profits like our hen house are completely dependent on generosity, and most of that generosity comes at the end of the year. It's really make or break time for us. And if we can raise $25,000 by the end of the year, it will be matched by a group of donors who are known as the Barnyard Benefactors. And if we can't raise the money by the end of the year, we're going to be in pretty serious trouble. As I record, because it's really, really hard to raise money during the course of the year and not at the end of the year. It's just how not-for-profits work. So as I record this with less than a week to go, we are not there. So please, if this podcast, we're getting there. We're not we're not disappearing, but we haven't made it, and I'm not positive we're going to. So please, if this podcast is of interest to you and helps you, and you think it has the potential to help animals, consider giving us a donation. Big or small, it is deeply needed and deeply appreciated. And I really do think that any not-for-profit that helps to get the word out is really worthy of charitable dollars. I really do. So if you do want to support us, just go to ourhenhouse.org/donate. Thank you so, so much. And we really, really appreciate all of the donations, big or small. They are all deeply needed and deeply appreciated. Anyway, now let's talk to Bryan Pease. Bryan is a California and New York licensed attorney. He focuses on government transparency, freedom of speech and assembly, and both enforcing good laws and blocking enforcement of unconstitutional laws to protect the public interest. He is also co-founder of the Animal Protection and Rescue League. Welcome to the Animal Law Podcast, Bryan.
Thank you. Thanks for having me on.
It's such a pleasure to have you on. And I know this is a case that people have been interested in to the extent they've heard about it and are going to really be interested in hearing some of the details on it. But let's start, as one always does, with the facts. And a lot of our listeners probably are familiar to some extent with Kapporot, which I'm probably pronouncing wrong, but because there seems to be 85 ways to pronounce it. But probably not all of them are. So can you tell us what was happening here that started this lawsuit off?
Sure. Well, so Kapporot is one of the pronunciations, and the other pronunciation I've heard is Kapporot or Kapporot. And it's a practice that goes back, based on various accounts, it may go back 700 or 800 years, and it's supposedly part of Judaism, but Judaism, of course, is thousands of years old, and there's no mention of it in the Torah, and it's not something that has, ancient significance. It's a ritual of atonement that takes place, or supposed atonement, I'll call it, because of the way that it's practiced, which involves killing usually chickens, swinging them around the practitioner's head, and then killing the chicken. And the idea is that you're transferring your sins to the animal. And then in the original practice of this, hundreds of years ago, the chicken would then be donated for the poor to eat. Well, fast forward to today when we have health code laws and sanitation laws, the ultra-Orthodox practitioners that are engaging in the practice have realized that they can't just hand over a chicken carcass that they slaughtered in a parking lot to a food bank, because that would be illegal under health code laws and sanitation laws. So what they end up doing is disposing of the birds. So, which, that even defies the whole purpose of the practice, because the point of the atonement ritual is that you're then feeding the poor with that animal that you killed, that you've transferred your sins to. So very few people have even heard of this practice, and most people that do practice the Jewish faith are appalled by it when they hear about it. And of those who do engage in this ritual, most use a different method, which your listeners have probably heard about too, especially if they're familiar with this campaign to end the use of chickens in Kapporot. The humane method of carrying out the same ritual, which has the same exact textual support in the authorities that the practitioners are relying on to support this practice. The other way to do it is to have a bag of coins, and then you circle the coins above your head, and you donate the coins to the poor or to a charity. So that's the way that most people who have even heard of and who practice this ritual would practice it. But there are a few places that use chickens, and it's a horrific scene. It's largely done in Brooklyn and in Los Angeles, and this is between Yom Kippur and Rosh Hashanah. The period in between, it's usually done a day or two before, and the chickens are just piled up in crates or boxes, and just crammed on top of each other, and then they're violently yanked out, and so there's a lot of animal cruelty involved. There's environmental violations that's occurring with blood, and cleaning material is being washed into the streets. So there are a whole host of issues that are raised, and we're addressing some of those issues in the state court in some litigation filed on behalf of the Animal Protection and Rescue League. And I'm doing these cases with Dave Simon as my co-counsel. And then we had another set of cases that were in Los Angeles, and along with Dave and Vanessa Shakib and Ryan Gordon, also other animal attorneys, helped us on those cases as well. But the breakthrough came in federal court this past fall, looking at the animal cruelty statute that we're relying on in California. It's Penal Code Section 597.
The federal case sounds really fascinating and really got to some of the issues. And I understand that the law under which you are suing is California's unfair competition law, which, when you first hear about it, you're like, what? How are you competing? But can you tell us what this law provides and how it relates to this behavior?
Sure. The unfair competition law, also known as the unfair business practices law, is a very powerful statute that we have in California. It's Business and Professions Code, Section 17200 is where it starts, and then there are a number of provisions within that section that deal with any type of unfair, fraudulent unfair or fraudulent business activity. And business activity is not it's not defined explicitly within the statute, so that's one of the issues that we're running into, is what exactly defines business activity. But in this case, there's no question that money is changing hands and that a profit is being generated, because the chickens that are being used are they're spent laying hens that are probably costing them, pennies. No way is it costing more than a couple of dollars per chicken. So they could order, a truckload of chickens for a few $100, and then if they have hundreds of people participating in this ritual, and each one is paying the set. There's an exact price that each person has to pay, and I think it's $27. So it is a massive fundraising tool for the Shabads that are doing this, and it's they're raising thousands of dollars. In some cases, it's their biggest fundraising event of the year. And we believe that is part of the motivation for the places that are continuing to do it this way instead of using coins, that there is that profit incentive. But just the fact that money is changing hands and there is a profit being generated, that falls within, in our view, business activity. Now, they will argue that, well, we're using the money for charitable purposes, or we're a religious institution, so it can't be for profit. Well, that's kind of a different question of what you use the money for, but a nonprofit organization can certainly engage in business activity, and if money is changing hands, then if people are paying to have a chicken killed for them as part of this ritual, that, in our view, qualifies as business activity. And so far, the courts have agreed with us, both the federal court, where one case is pending, and the California state court has also agreed, where we have a case pending in Orange County, that this does appear to constitute business activity.
So how does the cruelty law enter into this? I mean, you've established, or hopefully have established, that this is a business activity, but you had mentioned that the problem is that the cruelty law, in your view, is being violated. So what is this cruelty law, and how does it enter into the unfair competition law?
That's a great question. And so the reason that we're even talking about business activity and whether something qualifies as business activity is because, as private citizens and private organizations, we do not have standing to enforce the animal cruelty law or any of these other laws that we're alleging that these entities are violating. But the unfair business practices statute in California enables any entity to bring suit for an injunction. So we would be, our remedy would be injunctive relief against the entities that are violating these laws, to stop them from violating these laws. Now, originally, any individual or organization could bring suit in California against any business that was violating any law when the unfair business practices statute was put on the books. But back in 2004, there was a ballot initiative that was sponsored by some of these lobbying outfits that want to end the ability of environmental lawyers and public interest lawyers to be able to bring these kinds of cases. And there's a provision that was inserted into the law that requires economic injury. So we have to not only show that there's business activity, but that our client is somehow being injured by the activity. This is where there's a line of cases that Animal Legal Defense Fund was able to develop, and it happened as a result of the foie gras ban in California. Animal Legal Defense Fund sent an undercover investigator into a restaurant up in Napa, and they spent resources determining that this restaurant was selling foie gras in violation of the ban. And the Court of Appeal held, and this is the case is called Napa Partners. I don't have the full case site in front of me, but this is the seminal case on this issue. It was a few years ago that says that if an organization like Animal Legal Defense Fund, or in our case, Animal Protection and Rescue League, or United Poultry Concerns, which is our client in the federal case, if these organizations suffer a diversion of organizational resources, if their mission is diverted and they have to spend staff time or other resources dealing with illegal behavior rather than addressing their core mission of helping animals, and that can qualify as economic injury. So in our case, the argument is that our clients would like to focus their energies on educating people about why, for instance, chickens should not be used in Kapporot at all, or they want to focus on why people shouldn't be eating chickens or abusing animals in other ways. But instead, we've stumbled on this illegal behavior that we're now dealing with, spending time and resources trying to get authorities to take action and exposing and documenting behavior that's actually illegal, and because that's caused a diversion of our organizational resources, we can achieve standing under the unfair business practices.
So this standing that you need under the unfair business practices law sounds very similar to the kind of standing you need to get into federal court under Article 3. Do you use the same argument for both standing requirements?
It's a little bit different. So that was an issue that was brought up in the federal case, both the unfair competition law standing and then the separate issue of Article 3 standing and whether there's a true case and controversy here before the parties. But the unfair business practice statute standing is even a little bit more stringent because you have to show actual economic injury. So it can't just be that there's some intangible damage that's occurring. You have to actually be able to show dollars and cents. Here's how much you spent as a result of this activity. But the Article 3 standing is certainly, that's an issue that we briefed as well, and so far we're on solid grounds now. So one of the things that I alleged for that was that United Poultry Concerns is based in Virginia. The entity that we're suing is here in California, and we believe, based on the numbers, that the cost of the injunction to the defendants will exceed $75,000, the minimum jurisdictional requirement for diversity jurisdiction, over about 10 years. And the court asked, well, why 10 years? Why not 2 years? Why not 20 years? And I said, well, there's no set time period within the statute, but 10 years sounds like a reasonable amount of time, and that is about the time that we calculate that the injunction will cost $75,000 to this entity. And then we also allege as a separate ground that there's a Supreme Court case that deals with raising a substantial question of federal law. It's the Grable and Sons case, and it says that so ordinarily, if you have a federal question that's raised on the issue, on the face of the complaint, and the law that you're suing under there's a federal question that's directly presented, that's enough to get you into federal court for Article 3.
All right, so we've got a business practice, or at least you've got an argument as to it, and you've got standing under the statute and under the Constitution, and you have a federal question, maybe, which we'll get to, which we haven't talked about yet. But you still need one more thing to even state this cause of action. As you referred to, your basic argument is that the cruelty law is being violated here, and that's the unfair business practice. So let's talk about that cruelty law. What is California's cruelty law state that is violated by this particular practice? Like, not even getting to the constitutional question yet. Just what is happening here that violates California's cruelty law? Why is killing these chickens? I mean, people kill chickens all the time, but why is killing these chickens in this particular way a violation of the cruelty law? Right.
So initially, in the state court cases that we filed, and one of them, which is still pending in Orange County, we've based the violation of the cruelty law on the suffering of the animal. So Penal Code Section 597 has a few different sections, and one of them deals with causing unnecessary suffering, torment to an animal. And so we're alleging that the way that they're handling the animals and the way that they are grabbing them by the wings and swinging them around, and that the whole and confining them in the hot sun with no shade and no water, this all constitutes illegal animal cruelty. In the federal case, we realized that there's another section of the penal code that you don't even have to get into proving whether the animal suffered and whether it was unnecessary suffering and all that. It's illegal to kill an animal in California, period. To intentionally and maliciously kill an animal, and malicious is defined as without legal justification. So, and then there are exceptions. So, Penal Code Section 599C with no parentheses, so it's 599 and then just the letter C if somebody wants to look it up, gives certain exceptions to the general law against killing animals. And there are exceptions for killing animals used for food, hunting, medical research, the types of exceptions that we think about when we think about reasons that people kill animals. What's not in there is an exception for religious sacrifice or killing animals for religious purpose. So
yeah, and now we get to what's really the fascinating question of
real
this
constitutional
case.
question.
Yeah. So what is the argument that the defendants are making here? That I know it. I'm not even sure how to start this question. Maybe we should start it with the case, because I know everybody's talking about this case. It's the key case in this particular situation, and it's Church of the Lukumi Babalu IA, which is so much fun to say. I mean, I could just say that the name of that case all day. Can you tell, before we get into the facts of your case, can you lay out a little bit for us what happened in Lukumi Babalu IA?
Sure. So the Lukumi, and I'll just call it Lukumi for short.
You don't like to have fun.
So this was a 1992 case, and it was a unanimous decision where the Supreme Court held that a certain city in the state of Florida could not pass ordinances that were specifically targeting the Santeria religion. In that case, it was the Santeria religion that was sacrificing animals, and the city council had passed a set of ordinances directly targeting that religious practice, and the court repeatedly throughout the decision refers to the religious, they call it the religious gerrymandering of these ordinances that made it so that any other type of killing is fine, but if your motivation is religious, even if the animals killed in the exact same way, the exact same act under these ordinances would be illegal if your motivation was religious as opposed to something else. So this is completely different from having and in fact, the Lukumi case talks about if you have a neutral law of general applicability, then you can that would apply to a religious practice. Religion then becomes irrelevant at that point, as long as the law is not targeting religion. If the law applies to everybody, you don't get a special exemption just because of your religious beliefs. But it gets complicated because Lukumi was a very easy case because the ordinances were targeting the religious practice specifically. But in our case, we've got a general law that says it's illegal to kill an animal. There are exceptions for certain things. Now, note that if your motivation is religious, it's under the California law, it's still okay. You can kill animals for food, hunting, medical research, even if your true motivation is religion. So in other words, if your religion tells you, I've got to go out and shoot a deer or something, and your motivation is religious, the law is not concerned with that. It still allows that exception for the act. It's not concerned with your motivation. But just killing and disposing of an animal, and in this case, it amounts to this idea that you're transferring your sins to an animal. That could be done for a secular purpose too. You could just think that I did something bad today. I'm gonna, as part of my mental process here of atonement, and in other words, there doesn't have to be a deity involved. You could just say, I'm going to punish this animal for what I did, and as a society, we have a right to say, well, no, that's wrong behavior. You shouldn't be taking out your shortcomings on an animal and killing the animal for your sins or shortcomings or whatever you want to call it. The law is not concerned with whether your motivation for doing that is religious or some other motivation.
I know that the defendants in your case argued that this is definitely not a law of general application because there are exceptions to it. How did you respond to that? And do you find that Lukumi is often misread more broadly than is really justified by the case, which, as you said, was kind of an easy case?
Yes, it's definitely read way more broadly than is justified by the text of the case. But it's also a poorly written decision because it's internally contradictory, because the result was so obvious. You can't have ordinances that specifically attack religion and pass constitutional muster. But there were some passages in Lukumi that the defendants in our case are relying on that they believe makes it so that if there's any exception to a general law, that you must have a religious exception. Now, there's a great animal law review article on this. It was called Lukumi at 20, or 20 Years of Lukumi. and it was written in 2012, so a few years ago, and just laying out the legal landscape of where things are, how the lower courts have interpreted Lukumi, and it's varied somewhat. So there's the extreme, the sort of religious extremist position, which is what the defendants in our case are claiming, which is that if you have any exception, you must have an exception for religion. None of the courts have really gone down that road and found that that's the case. The other extreme would be to say you can have as many exceptions as you want for whatever reason, and you'd never have to have an exception for religious activity, and the courts haven't quite gone that far either, because there have been some cases where if you have two competing interests that come up at the same time, and they're basically the same, but one person